Okay, well, welcome to today's webinar. I'm Alex Solo. I'm the co-founder of Sprintlaw, and today we're going to be talking about the top 10 legal mistakes that small business owners make. It's actually my birthday today, so happy birthday to me, and I'm glad to be here spending my day talking about one of my favorite topics, which is legal issues for small businesses. We are, for those that don't know us, Sprintlaw, an online law firm designed to make legal services easy, accessible, affordable for startups and small businesses. Unlike traditional law firms, we don't charge by the hour. Everything we do is fixed fee with upfront pricing. We have an optional membership, which a lot of our clients sign up to, and it's a great sort of low-cost way to have a legal team that you can use for quick consults and to generate your own free legal documents. There's a ton of features that we're always adding as well. We have an e-signatures tool in there, AI features, and so on. So if you haven't signed up already, check it out. And there's a free tier if you just want to have a play around as well. A bit more about us. We've been around since 2017, have expanded from Australia to New Zealand and the UK, have helped over 10,000 businesses, won lots of industry awards, and we really love helping small businesses everywhere. Um, we're also running a promotion at the moment for new clients who are in need of legal help um, and move ahead before the end of the financial year, which is very, very close now. There's some discounts on services, uh, which I think actually applies to new and existing clients. And then if you become a member for the first time, there's some additional discounts as well. So just email our team at team@sprintlaw.com.au if there's legal help you want to get off your to-do list, or if you want more information about how this works. So let's get into the content for today. We're going to be talking about the 10 legal mistakes, or the top 10 legal mistakes that we see small businesses make. Now, this is based on uh, obviously some research has been done into small businesses, but also what we've seen in I think it's something like 35,000 jobs that we've done for small businesses. What are the top jobs? What are the top things that we see going wrong? And also, what are the sort of major case studies we've seen of issues that have occurred that could have been prevented? So we did some analysis and put together our top 10 list. We have a blog post online as well, and we sort of do this every year to have a look at what the major issues are. And we started doing this about 3 years ago, and the top 10 number has not changed that much in terms of the ordering and the sorts of issues. So these seem to be the things that in general small businesses are getting wrong. And we'll go through each of them in detail, but we'll be talking about number one, getting the business structure wrong. Number two, not having a shareholders or business partners agreement in place. Number three, not registering a trademark to protect the brand of the business. Number four, not putting a customer agreement or a client contract in place. Number five, not having contractor agreements in place with suppliers. Number six, poor employment law practices. Number seven, not complying with privacy laws. Number eight, not protecting intellectual property. Number nine, signing terrible contracts. And number 10, waiting too long to get legal advice in general. So we'll be going through each of these in a bit of detail. We have a Q&A feature in Zoom. If as I'm going through, you have questions about anything that I'm talking about, feel free to drop a question in the Q&A, and I will keep an eye on it and try and answer them. We may have some time at the end for questions, but I don't really mind answering questions as we go. So let's talk first about mistake number one. This is one of the top issues that we see um, small businesses make. Many people will set up their business starting as a sole trader structure or a partnership structure. Um, and they do so because it's quick, cheap, easy to set up. And either from day one or as the business evolves, um, they end up in a situation where a company structure would have been much better. And what ends up happening, or the issues that this wrong business structure causes, is A, if/when something goes wrong, the person running the business is personally liable for those issues instead of having a company. And we'll talk a little bit more about that on the next slide in terms of how that looks and what the differences are. But as a headline issue, they end up with personal liability. They can end up with tax inefficiencies as they grow. The company tax rate at a certain level becomes 30% as opposed to what may be higher if you're operating as a sole trader or through a partnership, or less than that now. It's in the 20s. And it can also be hard to scale the business if you want to bring on investors or business partners or even start employing staff. Not having the company structure can be a headache. And the issues that we see are, in some cases, we see people end up with liability and wishing that they had the company structure. But we also see a need for people to restructure their business from a sole trader to a company, which is possible to do, but becomes more and more painful over time, the longer that your business has been around. And often they wish that they had done it early on, because it can be difficult to, always possible, but difficult to unwind and restructure. So always best to pick the right structure for the kind of business you're building from early on. We have on screen the sort of three main structures that people use to run small businesses. We've got the sole trader, which is, as I was just mentioning, when an individual is just operating their business under their own name. We have the partnership, which is sort of like two or more sole traders working together. So in their personal capacity, they'll set up a joint business, and called a partnership. But ultimately, from a legal perspective, if somebody was to sue that business, that partnership, the owners or the partners are still sort of personally liable. And then we have the company structure where you can set up what's essentially a separate legal person to you, which is the company. And that company has its sort of own legal identity. It can have its own bank account. It can sign its own contracts. It will have directors who are sort of the arms of the company or the mind of the company that can sign agreements and control what that fictional legal person the company does. And then it has the shareholders that are sort of like the body of the company or the owners of the company. But it's its own person. And so if someone decides to sue a business that is a company, they can come after the company's assets, the company's IP, the company's cash, and so on. But the people behind it, with some exceptions, in general, are not liable. And it's from a liability perspective, a very robust structure, because you essentially have this barrier between you the owner of the company and issues that may occur. If a client decides to sue the business, it's very difficult for them to come after your house or your home or your other assets, if that makes sense. So yeah, we generally recommend for serious businesses that people consider the company structure. It's much better from a legal and risk perspective. If you want to introduce more owners in a sole trader structure, it's just you, so you can't bring on business partners easily. In a partnership, you can add more business partners, but it can be complex to do so, and everyone's sort of jointly owning everything as partners. As a company, it's much easier to have people have different stakes and different controls of the company, and then the company itself will be the owner of all of the business assets and so on. So it really gives you that separation, if that makes sense. We've got a couple of questions. Cash asked a question about shares agreement. I might answer that when we get to shares agreements. Jen said, is there a limit on how many directors in a company? There's no statutory limit on how many directors you can have in a company in Australia. So the key rules are, for a private company, like a PTY Ltd company, which is how most small businesses are run, you need to have at least one director. So there's a minimum, and at least one director must be a resident of Australia. So those are sort of the key rules. But you can have a one-person company. And again, people who are running their business by themselves may ask, well, do I really need a company structure? I am just a sole trader in the colloquial sense. You can still set up a company as a one-person sole director, sole shareholder company, and it can be very beneficial for risk management purposes and so on. But yeah, there's a minimum, there's no maximum. Sometimes people will put into place like a constitution or a shareholders agreement, which again we'll talk about in a moment, which might set a cap on the number of directors. But we have clients who have one director, two director, five directors. In some cases, we've seen 8 to 10 director companies. So yeah, you can have quite a lot of directors, if that makes sense. I won't spend too much time on this, but we do see people set up more complex structures. And again, there are some issues we see around this, both in the sense of people setting up structures that are too complex for what they actually need, and people setting up structures that are not complex enough for what they're trying to achieve. And so for those of you who are kind of already across the company structure, these are some other common structures that we see people use to set up their business. And particularly as your business goes from small to medium business, or if you have ambitions to grow your business, internationally or otherwise, or just to be a larger organization, you may consider setting up what we have in the middle, a dual company structure, where you have not only got your operating company that goes out and does business, but you may also have a holding company in between you as the owners of the business. Now, the advantage of this is, we were saying with a single company structure, as compared to the sole trader in the partnership, the big advantage of the company from a liability perspective is that the company is a separate legal person to the owners. It owns the bank account, the intellectual property, and so on. It can be sued, but the people behind it are generally safe. What can happen over time, though, of course, is that your company becomes very valuable, and you want to protect it as well. It might have more cash than even you do if it does quite well. So, for that purpose and other purposes, businesses often will set up a dual company structure where they create two levels. They have a holding company that owns all of the key assets of the business, and then they have the operating company that goes out and does day-to-day stuff like employs people and enters into contracts and does things. And what that means is all of the risk of the business sits in the operating company. And if something goes wrong, clients, customers, and others will have a claim against the operating company, but the holding company, which has a lot of the key assets, may be protected from that, because under the same principle of limited liability, the operating company is a legal person and the holding company is a legal person. And so you end up with this double liability protection where the operating company, which is taking on the most risk, doesn't also have all of the key assets. You have your kind of safety deposit box of the holding company. Another advantage of the holding company is if your business expands into other areas or into other countries, you can set up more operating companies. A holding company could have 5 different operating companies under. I mean, for example, for Sprintlaw, we have Sprintlaw Group, which is our holding company. We have Sprintlaw Australia. We have Sprintlaw UK. We're setting up Sprintlaw US. That means if something goes wrong in Sprintlaw UK, that operating company, the risk of the UK business is siloed to the UK operating company. The Australian operating company is a separate company, so it doesn't affect anything in Australia. And the holding company is also a separate company. So as your business starts doing more and more different things, having these different buckets through which you run them can be a very great way to reduce your risk. And some businesses, it doesn't have to be international, will have different business lines. You might have a marketing business and an advisory business and an education business that are all kind of related, but they're taking on separate types of clients. Now, if you're not making much revenue from them, it might not be worth the complexity of having 3 different companies for them and doing 3 different tax returns and so on. But if the business starts to grow, you might want to keep them separate because issues in business 1 might bleed into business 2. So those are other reasons we see people look at operating companies. With all of this stuff, you're trading off complexity with risk management. A company costs, between $600 to $900 to set up. Tax returns can cost between $400 to 600 per year. There's renewal fees. So, roughly you're looking at about $1,000 registration and then maybe $500 to $700 a year per company. Um, it's not millions of dollars, but it's not nothing. And so, it is very rational to start with a simple structure and wait until you get larger to restructure. Of course, there's costs of the restructure, there's headache with the restructure, and businesses that have big growth ambitions, we often recommend at least setting up the dual company structure early on because it can be very painful to move from single to dual when your bank account's all in one company. Now you're splitting it into two. All of the contracts you've signed are split to two. Your employees are in one company. You need to move them to another. It can be a really big headache if you haven't done it early on. And there can, in some cases, be tax consequences. So in the case of Sprintlaw, for us in our first 6 months of starting the business back in 2017, we did set up the dual company structure. We didn't use it for many years, for maybe 3-4 years, in terms of, we used it in the sense of having the two-level risk protection, but we didn't have any other operating companies. But when we did go to do that, it was a lot easier. That was already set up that way. That's one way to think about whether you do this early on or not. I won't spend a ton of time on the structure on the right. This has been a very common structure where you can see the bottom bit's the same. We have the dual company structure with the holding of the operating company. Up the top, the people that own the company, instead of owning it in their personal name, are using a trust to hold their shareholding. There's a couple of reasons people do this. One reason is whilst the owners of the business in the single and the dual company and the company structure in general are protected from employee claims or customer claims. There could be issues between business partners, and up at this level, these people don't have a company in between them in this dual company structure. So founders of a business could end up in a dispute, suing each other personally with no company sitting in between them. So in this model, we often see founders set up a trust to hold their shares. And so you can see founder one here is very well protected because a client can't get to them. They would only be able to sue the operating company. They would have to get through the holding company and their trust to get to them. And then founder two also can't sue founder one because they've got to get through their trust company. So they've got three shields here from any sort of risk. So that's one reason people use the trust company. The reason that people used a trust structure was in part for sort of tax purposes and flexibility of distributions and so on. The recent federal budget has changed some of the laws around particularly discretionary trusts. So unclear whether people will continue to use trust to hold their shares, but there is still, from a legal perspective, an advantage anyway, for the first reason I just mentioned, of having a founder of a business with multiple business partners considering not holding their shares in their personal name, but at least having a company or some other type of trust type structure as their shareholding. So they have that extra layer of risk. Again, it costs money, and so only maybe makes sense if you're really planning to really scale your business. But these are the more complex structures. For the vast majority of small businesses, the issue that we see is more about sole trader partnership structures that really should be companies. So I just want to make that point. These are more for businesses that are really trying to scale and grow, and their revenue levels are hitting 5-10 mil, or they plan to do that in the future, if that makes sense. Couple of questions on this. Cash has said, does the holding company own 100% of shares in the operating company? In the most common version of the dual company model, that is exactly correct. The operating company will be wholly owned by the holding company that's then split between the owners. There are some exceptions, where people are doing more sophisticated things, where they might have the operating company jointly owned by an investor who just wants to invest in one of the operating companies, but not the overall group. So sometimes you see so this is called a wholly owned subsidiary. When the operating company is owned by the holding company, you see non-wholly owned subsidiaries in some cases, but in the structure that we're largely talking about, yes, it's 100% ownership. And then we've had a question: if you are a sole trader and your major assets are in a partner's name, is this safe, or are these assets exposed? Interesting question. It is not automatically safe. It sort of depends on how those assets have been transferred, and probably requires some personal advice on the assets themselves to really give you a proper answer to that question. It can work if the assets is genuinely owned by somebody else. But if it's really yours and it's just been put in your partner's name to sort of hide it from creditors and so on, there are laws that basically will look through these sorts of arrangements. And so, if you are a sole trader and you suffer significant liability, um, and you at the last minute move all of these assets to be owned by your partner, that's less likely to actually achieve the purpose of protecting those assets. If they had always been owned by the partner before the business started and so on, then generally it would be safer. Um, but in all circumstances, that kind of model is much more risky than having a business run through a company structure. And probably it's more expensive to get the advice to make sure that that's been done correctly, if that makes sense. So um, yeah, that's not really a solution that we generally recommend for people in terms of protecting themselves from liability is putting assets in another person's name. We would generally recommend looking at the company structure as the way of siloing the business risk from you or your partner's assets, if that makes sense. So we've talked a bit about the company structures. Mistake number two that we're going to talk about is uh, the no shareholders agreement. So what is a shareholders agreement? A shareholders agreement is a contract that's put together between people that have set up a company together, or and it sets out how the company will be run, how disputes are handled, how key decisions will be made. What if one person leaves but the other one wants to stay? When do we need to seek each other's approval? And a whole bunch of other important factors in terms of the management or joint management of a business. If you are not running a company structure, it's called a partnership agreement. If you're a partnership, but it's essentially a similar thing. It's sort of the business partners contract. If you bring in investors, they'll also sign up to this agreement if they have a stake in the business or shares in the business. So it becomes the contract between not only the business partners, but all the part owners of the business. It's not a legal requirement to have this agreement, and therefore a lot of people don't do it because they A, don't know about it, and B, think it's not that important. It is one of the biggest issues that we see in businesses is there's a fallout between business partners, or sometimes there's not even a fallout between business partners. One person amicably leaves a business, and it's completely unclear what's meant to happen, and that leads to a dispute or an argument at that time. Having these agreements in place can, from the beginning, set the ground rules for how the relationship should run and really help reduce disputes. And B, if something happens, someone leaves, someone passes away, someone gets sick, there's a rule book in terms of exactly what is going to happen. Now, maybe you think with your business partners, okay, we'll figure it out. We don't know now how it'll work out, but we'll no matter what happens, we'll work it out later, and we don't want to agree anything up front. I mean, even if you want to make exceptions later, having a rule book in place of some sort that you could amend or make adjustments to is much, much better than having no agreement at all. And so, frequently we see these issues midway through a business where one person wants to leave or wants to change their arrangements or wants to reduce their time in the business or et cetera, et cetera. And there's no shareholders agreement or there's some sort of template that's been put together that doesn't really cover these issues. And this leads to these messy, expensive issues. And in more cases than I would like, we see it actually lead to a business collapsing when it may not have needed to. So, um, uh, you know, we generally recommend that anyone who's running a business with either investors or co-owners or a business partner of any kind consider putting in place this business partnership agreement, this shareholders agreement from from day one. And again, Sprintlaw, we're lawyers to tell you what we did in our first year of operation. First things we did were set up our companies. We did that dual company structure after a few months, but we set up a company. We did the shareholders agreement, two of us running the business, and then we did our trademark, which we'll talk about in a moment. So that gives you a real sense of like the what we think the to-do list is in that first year. So if you have put off some of those things, it's worth taking a second look as to whether you should have done that. We had a question earlier from Cash. Do you need a shareholders agreement if it's just your own trust, corporate trustee, shareholder? So no, if it's a one-person company or it's only owned by one stakeholder, it's true you don't need a shareholders agreement because there's not anyone that you're splitting your shareholding with. So this is only relevant usually to people with business partners, one or more, or investors or part owners of the business who may not be working in the business but have put in some money for a stake in the business. Those are the circumstances where you need this agreement. So if you're just a one-person business, it's just you and there's no one else, this is not relevant to you. And but we do see this for many businesses. This gives you a sense of what goes in these agreements. I mentioned them earlier. We've got decision-making processes, which will say, okay, well, these decisions we can just make by ourselves, but these bigger decisions, we need to vote on them or agree to them in writing. And that stops you situations where if someone goes off, one business partner goes off and does all kinds of things, adjusts their salary, opens bank accounts, takes out loans. It's clear that in some circumstances they were allowed to do that, but in those circumstances they might have needed to seek approval before they did it. So it makes it clear what requires approval and what doesn't. Vesting schedules, these are things lawyers very commonly recommend. If you have two business partners, for example, 50-50 in the business, they make a commitment that they'll stay in the business for a period of time. And if one person leaves after 1 year, they'll lose in less than a year, they'll lose their whole stake. If they leave after a year, but less than 2 years, maybe they lose 75% of their stake. After 3 years, they lose 50%. After 4 years, it becomes locked in or some other schedule. And that helps manage the risk of somebody leaving early and the other person running the business for many more years and, still having equity owned by a person that they thought they were going to work with, but it didn't work out, if that makes sense. That's sometimes agreed at the beginning. Also, for any startups here that want to raise investment, if you don't have a vesting schedule, many investors who invest in your business will make you introduce one at the time of investment. Because again, if someone's putting money into the business, they want to make sure that it's not owned by someone who's not contributing. So that's a very common issue. We see people have split equity evenly. One person wants to leave. The person who's leaving, if they haven't signed a vesting schedule, has a lot of leverage to say, well, I don't have to sign anything. I'm just going to sit here and keep my big stake. And often something's negotiated, but the leaving party has a lot of leverage to get a better deal than they otherwise would had something been agreed up front that they were going to give up a certain amount when they left, if that makes sense. So very important clause. Drag along and tag along clauses cover this situations where usually when you have more than two shareholders, the majority want to leave them, want to sell the business, the minority don't. The drag along allows the majority to force the minority to sell, so you don't end up with these deadlocks. And similarly, tag along, if the majority want to sell out and leave the minority behind, the minorities can force themselves to be included in any sale. So this is when you end up with bigger and smaller shareholders, a useful clause. How does this agreement end? How does it change? Non-competes to stop people like leaving and setting up the exact same business with cutting out one party. How are disputes handled? When are dividends issued, and who has to approve them, and how much will they be? And so on and so forth. Can you bring in new shareholders without first offering those shares to existing shareholders? We have this thing called the right of refusal. So, lawyers have over time thought through and seen most of the issues that occur in business partnerships and created a set of principles that we usually cover in shareholders agreements. Every shareholders agreement is different because there's different numbers of shareholders, different dynamics, different preferences, and so on. The concepts are all fairly similar, but the fine-tuning of what you do depends heavily on your circumstances. So it's not a document you want to use a template for, or you want to DIY. we can talk about that a bit more later on, but this is also one of the high risk DIY documents that we see people do. They say, I just use a template for that. It's very, very risky to do that because this is important stuff. This is like the ownership of the business, which you presumably care a lot about because you're going to be spending a lot of time building the business. And to leave the mechanics of how it all works and what you might own to something that you don't understand is quite risky. So yeah, strongly recommend people put one of these in place if they don't have one already and they have business partners or part owners. Um, uh, see if there's a few questions on this. A question from earlier, can we have a holding company and not have the operating company for a while? I'll just flip back to that slide to answer that question. No, well, yes, you can do that, but that's not really the point of the holding company. The holding company is meant to be a very clean company that that doesn't do anything. It never signs a contract. It never employs anybody. It just owns your core assets, which means no one can ever sue it, which is why you're going to put like all of your important stuff, your IP, if you've got a large cash balance, that can sit in your holding company. So if the holding company's out there doing business for a while, it's getting a little bit uh, messy in terms of it being a clean company that's safe from risk. Now, many people start off with a single company structure and convert to a dual, if that's what you're asking. That's very, very common. People will start with a single and convert to a dual. The risk is, though, what I just said. There's two ways to convert from a single to a dual. Either you introduce a company underneath, which is your holding company, or you introduce a company in the middle. Introducing a company underneath is simpler, but as I said, if your company becomes your holding company, if you've done risky things in your first few years, you've got an unclean holding company. Someone could come out of the woodworks 5 years down the track and try and sue your holding company, which now has all your assets. So the longer that you wait before you add the holding company, it can get complex. Or if you do it the other way, you create a fresh holding company, you essentially have to sell the shares that are owned in the existing company to the holding company. And there can be, if the business is doing well at that point, like tax payable on that sale. Now, there's ways with accountants that you can reduce that or use rollover and so on, but there can be issues with that. So you can definitely wait. The longer you wait, the more risky and complicated it becomes. So it's common for, I mean, we generally recommend if people are thinking about the holding company, operating company structure, they think about doing it at the earliest possible opportunity to reduce those risks. Okay, and then Cash asked a couple of questions about sounds like a JV agreement. A shareholders agreement is a bit different to a JV agreement, although they are similar in nature. A JV agreement is usually the term lawyers use to refer to sort of two separate organizations, businesses, investors working together on a single project. So you might, instead of having two business partners sign up to an agreement, you might have two companies sign up to an agreement or two businesses sign up to agreement, and they're doing a joint venture together, but it's a one-off venture rather than it being the core business. It's largely semantic in terms of what you call the agreements, but JV is usually used in that. So, for example, Sprintlaw decided to work with an accounting firm to create like a law and accounting product. We might do a joint venture with the accounting firm, and we may have a joint venture agreement that's similar to a shareholders agreement, but a bit different. So that's usually what we talk about when we're saying a joint venture. Whereas a shareholders agreement is, within your primary business, the relationship between the business partners and the shareholders. So hopefully that answers that question. So let's talk about trademarks now. Trademarks are another major miss that we see small businesses fail to sort of register protection for their brand. Now, for those of you who've set up a sole trader or a company structure, you would have in many times gone through a process of selecting your name for your business. And when you register as a sole trader or as a company, there's an option in Australia to register a business name. And it's a requirement if you are trading under a name that is, in the case of a sole trader, different to your own, or in the case of a company, different to your company name, there's a legal requirement that you register that business name. If your company's called, um, Example Foods Pty Ltd, and you want to create, famous burgers, famous catering, and so on, but your actual registration is under Example Foods Pty Ltd. Legally in Australia, you have to register a business name for, the famous burgers, the famous catering brands. And the reason for that, the reason that that's required is because, um, if someone in the public sees your marketing or sees your business, they should be able to look up who's behind that and be able to find a link back from the business name to which company or registered sole trader owns it. And similarly, if you're a sole trader called, John Smith, and you're starting John's Plumbers, John's Plumbers would need to be registered as a business name because you're not out there trading as John Smith. So that's a legal requirement, and many people do that correctly because when they set up their business, they knew they needed to register a business name. That is not a trademark though, and a trademark is a separate thing that is a different registration with a different government body called IP Australia. And if you register a trademark, you get exclusive rights to use your brand name, your uh, a logo if you register that as well, any taglines that you might have, any names of products that you might be using. If you register a trademark, you get the exclusive right in your industry or class in a particular country to use that phrase. So uh, people may think they own their brand because they registered a business name. That's just an Australian law registration requirement. That doesn't give you any ownership of the brand. And it's totally possible that, for example, I could register a business name called, uh, you know, Apple iPhones Pty Ltd. Well, sorry, I could start a company and then register a business name called Apple iPhones Sydney, for example. No one may have a business called Apple iPhone Sydney. That doesn't mean, and I might get a registration through because that name hasn't been used before, and it's the only one in Australia called Apple iPhone Sydney. Well, turns out the reason no one's done Apple iPhone Sydney is because Apple's going to sue you the second you start trading because you've got the trademark Apple and the trademark iPhones in your business name. So that helps you understand the difference between the business name and the trademark. Apple owns the trademark for Apple in the technology industry. They don't own it in the fruit industry. That would be not allowed because it's an everyday word, but they own the trademark for Apple in the technology industry, and they own the trademark for iPhone as well. So you can sort of see how the two interact. So if you don't already have a trademark for your business, we strongly recommend that you protect it from very early on. And sadly, this is again one of the biggest issues we see. People will start a business, they'll use a brand name, someone else already has a trademark, they don't know about it, and they operate for a while, they fly under the radar, they get all of their collateral done, their website done, all of the t-shirts and everything done. And then after a couple of years, a cease and desist letter comes through because they're doing pretty well. And either they're sued or in more cases, they just have to rebrand the whole business. And it's a huge expense, a huge headache, and a lot of goodwill is lost because they've been building for years in their name. So um, uh, you really want to make sure that you secure that name from early on. And if you've got a unique logo, you can secure that too. And then that's your brand stamp, and you sort of own that. And I got this slide here, which helps. There's a lot of related concepts with the name when you're setting up. You've got the business name I was just talking about. You've got the company name. If you set up a company, you've got the domain name, which is your website domain, and then you have the trademark. They all seem related. They're four different things. So here's the example of Nestle. Nestle Australia is the business name. Nestle Group Pty Ltd is the company name. Nestle.com.au is a domain name, and then they have a trademark for Nestle for that design, for Uncle Toby's Oats, for Nancare, some of their products, if that makes sense. So this is, if you apply that same analogy to your business, you can start to think about, okay, do I have my business name? What is my company name? Obviously, do you have your domain name? And then have I registered my key brands as trademarks? Yeah. Again, in my view, if you are a business with a brand, you should consider registering a trademark for as soon as possible after the business starts. Now, there are some businesses, there's lots of rules around trademarks. You can't register descriptive trademarks. If your business is um, you know, apple and banana grocers, that's what you're called. It'd be difficult to get a trademark to own apple and bananas because they're very descriptive terms, at least in the fruit industry. If you were called apple and bananas marketing or apple and bananas cleaners, you might be able to get a trademark in that industry because it's a bit more unique. So there's all kinds of laws around what you can and can't trademark. Um, and you don't have to have a trademark for your business name if it's untrademarkable because it is something that is seen as not uh, uh, distinct enough to get a trademark. Then no one could ever get a trademark, and that's its own form of protection, knowing that at least you can operate without having to run the risk of infringing. But if you can get one, it can be very, very powerful. And so, for example, for Sprintlaw, we have a trademark for our name, Sprintlaw, in the legal industry, and I can't see our S-shaped logo anywhere here, but we have a little. People may have seen our logo. We have a little S on the logo. We've registered a second trademark for that S shape. And that means no one else in the legal industry can use the word Sprintlaw to promote legal services, can use our S logo stamp to promote legal services, or anything deceptively similar to Sprint Legal wouldn't be allowed, Sprint Lawyer wouldn't be allowed in the legal industry. Someone could start a food business called Sprintlaw that does very fast coleslaw. It would be a terrible business name, but it would be in a different industry, so they may be able to operate that. Our trademark does not extend beyond legal, but within legal, we own it, and we own it in Australia, in New Zealand, in the UK, in the US, and a bunch of other countries that we registered as well. So that's kind of how it works. A few questions I can see about trademarks. Jen's asked, can you register a trademark without a business name? Yes, you can do that. In many cases, a trademark isn't even a business name; it's a product name, right? So, like iPhone is a trademark. Apple don't have a business called iPhone, so you absolutely can. If you never use it, people can make an application for non-use and say you're just kind of squatting on this trademark, and you can lose rights if there's a extended period of time that you're not using it for. But if you have genuine intention to use it and some evidence that you are using it a bit, then people do that all the time in terms of coming up with a great brand name that they want to protect in anticipation of setting up a business. So yes, that is possible. Cash is said so you have to register PTY Ltd, domain, business name, and trademark. I mean, yes, yeah, I mean, all four. I think you said all three there. So all four, uh, for sure. For businesses, with some exceptions, depending on what your business does. If you are running a company, trading under with a brand that's unique, and you want to have a website and so on, you would do four registrations. So you would do the company registration with your company name, the business name for the friendly name you use publicly with customers, which is a legal requirement, a domain name, and also your trademark registration or registrations. That's exactly right. Um, and then Rodrigo's asked, does a trademark have worldwide protections, or do you have to register the mark in other jurisdictions as well? Great question. So when you register a trademark, you register in a particular country and in a particular industry. So in Australia, we have IP Australia. You're only getting exclusive rights in Australia and only in the class, which is similar to industry that you registered in. So when Sprintlaw registered Sprintlaw in legal with IP Australia, we only had rights in Australia. We needed to do separate registrations for each other country. And we had issues in other countries. There were some issues in Canada because there was people with some similar names, some issues in the US and so on. So the issues will vary by country. And so you do not automatically get worldwide protection. Now, there is something called the Madrid Protocol, which is a treaty between many countries, not all countries, which allows you to, through a fairly streamlined process, once you're in the process of securing your Australian trademark, you can sort of upgrade through the Madrid Protocol, and with it can save you having to go see lawyers in 6 different places. you can just upgrade and add a few more countries for additional costs, and it'll kick off the registration process all at the same time. But the time period to register a trademark, I should mention, is not short. In Australia, it's from lodging to actually getting registered if you're successful is 7, 8 months minimum. You've got to first pass IP Australia's initial test that this is actually original. Then it sits in a pending sort of state for anyone who has an existing trademark to lodge an objection saying, I don't like that one, it's too similar to mine. And only if you make it through that objection period do you truly get the rights. And in other countries, some of those periods are shorter, some of those periods are much longer. In Canada, it can take a year or two to get fully registered. So another reason to start early. And you may not register in every country from the beginning. It can get quite expensive. It's sort of $500 to $700 to do one trademark in one class in Australia. And then if you're adding on more things like a logo, it can get to $1,000 and the cost can add up. And if you add on more countries, it can move to $1,500, $2,000, $3,000, or many, many countries can get more. So it gets quite expensive. So it's, again, rational to balance the risk that you're against how much money you can afford to spend right now. And many clients of ours will start with just Australia and maybe a country that they're really sure they're going to go to. And then as soon as they become more certain about other countries, we'll try and pin it down. But there's risk associated with that. And sadly, we've had clients, at least one case study of a client who followed that strategy and waited to do their UK registration until they were a bit bigger. And in that intervening period, another brand emerged in the UK and had built up a reputation. And so had they registered from day one, they would have had the UK mark, but they lost it and had to do a costly rebrand for that market. So there are risks, and you just have to balance the amount of cash that you're spending up front with the probability that you're going to go to those other markets. A bunch of great questions here. I might keep going through because we're not going to get through this 10 if I answer them all, and then I might spend some time at the end answering some of these questions, which are really good. So let's talk about mistake number 4. We have no customer terms. So this is a situation where many small business clients are engaging customers without a proper set of client terms and conditions, a client contract. If you're a services business, it might be called a service agreement. It might be called a business terms and conditions. If you are a software company, it might be called your SaaS T's and C's. If you're a goods business, you sell goods online or physically, it might be called a sale of goods agreement or an e-commerce terms and conditions. They're all a similar grouping of document, the contract between your business and your customer. We call them customer terms. Many businesses do not have customer terms, or they have some template that they created themselves, downloaded online, or these days, use ChatGPT or something for. Having no or very poorly drafted customer terms is very risky. This contract is, of all the contracts you might sign in your business, one of the most used agreements. Every time you're dealing with a customer, you're essentially forming a contract with them, and you want that contract written down. What happens? How does payment work? What if there's a dispute? What's included in the service? What if something goes wrong with what you're supplying them? What's the liability? What can they sue you for? A well-drafted contract can protect you from many risks and issues, and help again prevent disputes by providing certainty. These are the kinds of things you can put in your customer terms: a clear scope, the term of a contract, how renewals work, how people can leave, are there cancellation fees? If something goes wrong, you can put in liability caps, really important. If there's an issue with a customer, the most they can sue you for is X. There was a client that we had as an example of this, who we've done a case study on, so I can sort of share the story, who was running a marketing agency, managing marketing expenditure for one of their clients. And they'd been given a budget to spend, and they accidentally spent 20 times the budget because they got some settings wrong in Google Ads and spent way too much of their client's money. And the client was a very large business and had theoretical liability of hundreds of thousands of dollars in this case against the small business, and tried to make a claim against them. they had a contract with a liability cap that said, look, we're providing these services to you, but the most that you can sue us for is, 3 times the fees that you paid us, not hundreds of thousands of dollars. And so the business was able to continue operating because they had a liability protection in their customer terms. Um, that one paragraph in their customer terms in that case was a mistake occurred, and it was the difference between bankruptcy for that business, or insolvency is a term we use in a business context, and them continuing to operate. And they were able to say, like, look, you should have had some greater controls on your spend because our liability was not unlimited. Now, you can look at that from both perspectives. If you're the customer, you want to make sure that your suppliers are going to be liable if they make mistakes. But if you're the supplier and you're worried about something going wrong in your business, knowing you have good liability caps um, in your contracts that are well written and will stand up in court and so on and so forth, can, in those freak accident scenarios, save your business. So that's liability clauses are really, really important. If there's confidential information that you're dealing with, confidentiality clauses, IP clauses to make sure your customers don't steal your work, depending on what you do. How are disputes handled? Can they sue you, or do they have to give you a chance to rectify things first and speak to them? Payment terms. What if they don't pay on time? Can you charge late fees to incentivize payment? Are there upfront deposits? How do refunds work, and all these sorts of things? Leaving this all up to vibe, or even self-written bullet points, is risky. Again, like proper contracts, the wording is tight. These issues have been thought through. Um, uh, and a lot of people DIY these terms. People maybe don't have no terms, but they have something that they've either created themselves or, again, used AI these days. Um, the risk of doing that is that these things are written badly, and a thing that's written badly can be worse than having nothing at all. Like, one issue that we commonly see is people use a service agreement. They'll say, "Oh, make me a service agreement," and to an AI, or they'll download a service agreement template online and then use that for their services. But the service agreement template that they've created is a customer-friendly service agreement, not a service provider-friendly service agreement. So instead of it saying the most I'm liable for is X, it says you can sue me for any mistakes, because that's what the customer would want, if that makes sense. So the document may be named correctly, but the prompt that went in the case of the AI, or the template that was selected in the case of using a template, may not be perfectly tailored to the circumstances of the business. And if you get it wrong, can make it worse for you than if you had nothing at all. So this is why there's a bit of expertise involved in getting these documents done correctly, and so worth considering. I view this as, like, you're going to use these terms and conditions all the time. Do a one-off investment in getting it right. Maybe check it once a year to make sure it's still up to date, and just stay on top of it. You don't need to get every single contract checked before you sign it with a customer, but having a good base template can make a really, really big difference. Uh, and the final thing to mention is, some businesses, this may not be, I mean, if you run a cafe and you're making coffee, you're not going to get a customer to sign a waiver before they drink their coffee. I promise that if this is too hot, I won't sue you. So there are cases where it can be impractical to have these terms and conditions, but for many businesses, it's not. And if you can have one, I'm sure people wouldn't mind if they could get a liability waiver from every cafe owners wouldn't mind getting a liability waiver from anyone that enters their cafe. It's just impractical for the business. So it's not because it doesn't add value. It's just because in those cases it's impractical. And it's the same for your business. In some cases, you may be able to have a 40-page document. You may only be able to realistically have a 2-pager for your customer terms. Otherwise, it will put your customers off. But you can still include a lot of detail in short form agreements, and there's ways to design it that do protect you. So that's how you might think about that. Mistake number 5, we have no contractor agreements. These are situations where you're bringing on contractors to work in your business, freelancers, and they're going to do stuff for you. Maybe they'll do web design. Maybe they'll design a brand. Maybe they're going to provide services to you. Maybe they're going to help you with supply of goods and so on. Having these relationships with nothing in writing can be very risky. If they're making valuable IP for your business, it's unclear who owns it. By default, in many cases, they may own it instead of your business. if they are handling confidential information, can they go reuse it, or do they have to keep it confidential? Can they steal your clients, steal your customers? How do all of those things work? And there are also laws which are constantly changing for better or worse in Australia, and have recently changed in the last 18 months around when you have people who are contractors but you work with them very regularly. They can be what's called a deemed employee, and they can make claims for, unpaid super and unpaid workplace entitlements against you if things are not done correctly. So these contractor agreements can be very important for clarifying the relationship, making sure that you own the IP that the contractor has created for you, um, making sure that it's clear what they're providing, like what is the scope of their service. Are they going to keep charging you more and say that's out of scope, or are you getting what you paid for? Um, Clarifying that they are a contractor and not an employee, and structuring the relationship in a way so that you don't have that deemed employment risk, the restraint clauses, the payment terms. So again, a very important document that if you have a contractor doing important work for you, again, it's worth having a template in place to make sure you you're across what they're doing and reduce these risks. And similarly with mistake number 6, we have our poor employment practices. And this is another big one where you have businesses who are hiring staff and not following workplace laws in the way that the staff is hired or managed. And this can lead to unfair dismissal claims, underpayment claims if people are paid under what they should have under awards, and Fair Work can issue penalties for non-compliance. And again, the enforcement and the penalties for this stuff has, in the last 18 months, with some reforms to Fair Work laws, have gotten more significant. So it's more important than ever to make sure that you get your employment practices sorted. And this starts with having a really good written contract that sets out what people are getting paid, confidentiality, obligations, workplace policies, making sure they're getting paid super at appropriate times, making sure they're getting the leave that they're required to get, making sure they're paid at least minimum wage, being given documents that are required by law for them to be given when they start, as well as award selection. For those who don't know, in Australia, for most industries, in addition to national minimum wage, there are minimum standards that employees in specific industries need to comply with, which include things like overtime rates, higher minimum wage levels for specific types of services. So, for example, in the legal industry, we have the Legal Services Award, which sets out the maximum shift time that we can set for casual employees, rates of pay for different levels of casual and part-time employees, and so on and so forth. So you can't pay people less than their minimum wage, both at a national level and at an award level. And so we see that all the time. Small businesses just set up as I'll pay you this. And that amount they've selected actually is not enough to comply with the award that the employee's under. And making sure that if there are issues with employment, the dismissals are handled properly. There's fair processes, there's warnings, there's performance management, and all these sorts of things. Otherwise, people are able to make claims for unfair dismissal to say, oh, well, my employment ended in a way that was unfair or discriminatory, or I wasn't given a fair chance. And there can be penalties and fines and back pay for those situations as well. So if you have employees, these are the kinds of issues that you want to consider. At minimum, start with that contract. Make sure you're paying them enough. Make sure you're paying them the right super, and make sure you've selected that right award, and the way that you're paying them and the shift times and all those sorts of things comply with the award. Conscious we're at 1, I'll probably go for another 10 to 15 minutes for those that want to stay. There will be a recording circulated if people do need to drop off. I think there was a question about that earlier, but I will continue on for, as I said, another sort of 10 minutes or so. So mistake number 7, we have privacy non-compliance. So these are requirements for small businesses to collect customer information and provide informed consent in terms of how that information's being used. So There is in Australia currently, although it may be abolished in the next 12 to 18 months, an exemption for small businesses, for most but not all small businesses, where our key privacy law in Australia, the Privacy Act, does not apply to businesses doing under, I think it's 3 million or 2 million in revenue. And so many small businesses do not need to comply with the Privacy Act. There are other privacy laws at a state level, and there are marketing laws, and there are exceptions to that exception if you collect certain types of information. So it's not an exception that we suggest people rely on. And as I said, it may be abolished soon. So we suggest everybody complies with privacy laws. It may not be as big a risk for smaller businesses in some areas, but it's becoming a bigger and bigger part of the Australian legal landscape. So, and it builds trust with customers to be transparent about how you hold their information. So privacy, what we're talking about is personal information that you may hold about customers or employees, their name, their email address, their phone number, anything that you look at and you could use it to identify them. So the key requirement under privacy laws are having a privacy policy in place. Most people put it on their website. It basically says, hey, when you provide me your personal information, your name, your address, your phone number, and so on, this is how I'm going to use it. These are the purposes for which I use it. I'm going to use it to provide you with services. I might use it to send you a marketing newsletter. I may share it with my contractors and suppliers. You can contact me here if you've got questions about it. And you consent by filling out this form or providing it to me for me to use it in these ways. Getting that consent is really important. If you get that consent, you now have some freedom to use that information. If you don't get that consent and you start using it that way anyway, that's where breaches of privacy laws can happen. So these top two requirements are privacy policy. Here's how we're going to use your information. And then a collection notice, which is just a few words that you'll have on the form. You agree to our privacy policy, which applies to the way that to the information you're about to supply. These are important requirements to share with your customers. And then these sorts of things will be included in the policy, like who are you sharing it with? Does data go overseas? Where's it being stored? How can people opt out? Are you using it for AI tools? They're going into AI systems. You can cover that too. And also, if there's a breach of their data, how you'll notify and respond to that breach. So these are the kinds of issues you want to be thinking about with privacy. And again, a lot of businesses are not doing any of this stuff or using the wrong privacy policy type templates that comply with international laws or non-Australian laws. So getting this right can is something that they still need to do. Mistake number 8 is about intellectual property protection. We already talked about trademarks, which is one form of intellectual property, but there's also other intellectual property. You may have people build software for your business or write blog content for your business, or develop other valuable original works for your business. Now, the way copyright, which is the other major form of IP other than trademarks that we see emerge in business works, is the author of a piece of work by default will own that work unless they assign it by contract. So if you get a software developer to create a software for you, they own it by default at the moment of creation, unless they sign something that says, at the moment of creation, I agree to assign the ownership of this software to this other business. Even if you've paid them, specific wording needs to be in writing to transfer that ownership. Otherwise, they still own it. So a lot of people think, I paid them for it, so it's mine. It's like the pay copyright law. There must be something. There's no such law that if you pay them, you automatically own it. You need these contracts that assign the ownership of the software, or it could be graphic design work or anything that's original and creative that someone's created for your business. You need it's usually done in the contractor agreement I mentioned earlier. There's a paragraph in there that says, I, the contractor, agree that any copyright I create in the course of my work is owned by the business. But absent that wording, you may not own your IP, and they may start reusing it with other clients or using it for themselves. And one day, if you decide to sell your business and whatever they've created is important to you, people will ask, well, who made this for you, and did they give you ownership? And if you can't produce the contracts, you run the risk of making it harder to sell the business. So making sure that anyone that makes valuable IP for you signs something is really, really important. Related to that, we have mistake number 9, signing bad contracts. Now, if you're operating a small business, you don't have lawyers on call all the time to look at every single thing that you sign, and you may not be able to afford legal reviews for every type of contract. So it is rational and understandable to sign a whole bunch of contracts that you never get lawyers to look at because you simply couldn't afford it. We understand that that may happen in bigger businesses. It doesn't really happen. They have lawyers look at everything they sign, but in smaller businesses, you may not have the luxury of having a lawyer review your Microsoft OneDrive terms and conditions or whatever it is. What we suggest though is for key contracts, important arrangements, things the risk of something going wrong is higher, or it's just an important commercial relationship, or you might be taking on a lot of risk in the relationship. You're doing something tailored for a customer. These are situations where you want to reach out to a lawyer. If you sign an important contract that you don't understand, you could be agreeing to all kinds of stuff that could be very, very risky. One of the biggest issues we see is liability. People will provide services to medium-sized companies. The medium-sized company or large company will say, "Hey, small business, sign this thing." Because I don't want to use whatever terms and conditions you have. And they go, "Okay, I want this client, I'll sign this." What the fine print says is you, the small business, will be completely and unlimitedly liable for any issues that you occur in our business. If you make a mistake that costs us money, we will be able to sue you for, um, tons of money. And there's no cap on your liability. Again, you may be signing business-ending contracts without realizing what you're signing. And we see this happen. And sadly, there are cases which are the inverse of the story I told earlier, where a small business has signed up for something with a big business and something went wrong and it put them out of business. So be careful what you sign. You may not have the luxury of getting everything reviewed, but it's worth at least understanding whether what you're signing is likely to be higher risk and then getting somebody to cast their eyes over it. And then finally, and then I'll get to some questions. Mistake number 10, we have waiting too long to get advice. A lot of people, and it may just be the media reputation of lawyers, I think that lawyers are people you call when things go wrong, and treat lawyers sort of like emergency services. Say, "Oh, well, I hope nothing goes wrong, but if it goes wrong, I'll have to go get a lawyer." Now, that's true. If something goes wrong, you should go get a lawyer, but problems are far more expensive to fix than preventing them in the first place. And so we do recommend getting advice early. If you haven't gotten fulsome legal advice about your business, you might just want to book in a consultation with a lawyer to talk about your business more generally and what the major risks are, and put into place some protections. Get those brand protections, get that structure right, get those key contracts in place, make sure you've got basic employment practices set up. Once the basic infrastructure is there and you have a good working knowledge of how it works, the risk of something going wrong dramatically reduces. And when something does go wrong, you have a process to follow. If you have a client contract with a dispute resolution clause that's well written, then when something inevitably goes wrong with the client, it's not a disaster. You just say, "Well, here's the contract and here's what we have to do. And here's how the refund will work if there is one," but there's no risk of, "Oh, this person might sue me. This could end my business," et cetera, et cetera. Same with the business partner as well. If I wake up one day and my business partner decides they don't want to do business anymore, we at least have a framework for agreeing that. Or if the privacy regulator comes knocking, I have some practices in place. Or if the employment regulator comes knocking, or there's an issue with my staff, I know I'm on top of my employment obligations and I have a method for resolving it. That is a really stress-less way to run a business. And there is some time and effort involved in setting it up, but it's really not rocket science, and it's been done before because there's many businesses out there that have got this right. Sadly, we often receive the call and we say, "Well, it would have been better if we had something up front, but we'll do our best to help you." So try and avoid being that person, if that makes sense. So those are the 10 risks I wanted to cover. I'm going to go through these questions, and probably stick around for another 5 minutes if people want to ask any other questions. But let's go through them. So we've got from Cash, looking to start a marketing agency. Do you have a budget template to start? Um, I mean, we're like a law firm, so we have some free template docs in our subscription, but the kinds of things you need as a marketing agency are obviously you want to get your company set up, you want to get a client contract in place, as we mentioned earlier. If you've got staff, there may be staff agreements, maybe there's a brand protection. So we have fixed prices for a lot of those things I mentioned. So do feel free to reach out to the team. And again, if there's stuff you want to get done soon, we have the good rate at at the moment. Um, and yeah, I guess you have another question there um, about IP. So yeah, that's a good question. With the trademarks, can you start with one trademark and then once you have more income, add second? That is very common. People will often start with the word trademark for their brand first. So for example, Sprintlaw, we registered Sprintlaw, the word first. Then later on, we added the logo once we were happy with it. And then later on, we added business legals made simple, which is one of our key phrases. So they all helped, but the biggest protection was the core brand. Because if we had to change the logo, it wouldn't end the business. So that's kind of how we sequenced it. So yes, you absolutely can sequence things. It's often it can be cost efficient to do things together as well. But you can sequence it if you want to wait over time. Len's asked, where can we check trademark before giving a name for the company? IP Australia has something called TM Checker. If you just Google TM Checker, there's a tool that's meant to make it really easy for at least checking Australian trademarks. It's not that easy to do it yourself though. Like there are there are some laws around, like it's not just about exact match. I said before, we own Sprintlaw. That means you can't do Sprint Lawyer or Sprint Legal. Could you do fast law? Maybe that's might be different enough. So it's not about exact match for trademarks, and so you might actually want to get a little bit of legal advice if your name is on the edge. But you can get a sense through that TM checker tool, and then yeah, usually we recommend considering getting some proper advice as to whether your name is trademarkable or not. Um, Melissa said, does Sprintlaw take clients with art and creative businesses as well as innovation startup? Absolutely, we do. I mean, most of we help small businesses across all industries, and we definitely help startups and tech companies, but that's a minority of our overall client base. We're quite spread out across many different industries, and we've helped hundreds of creative businesses. It's actually one of our bigger areas, so very happy to help. Got a question here, a couple of questions together, I think. If I register a trademark for my business but operating as a sole trader, would it be difficult to assign that trademark to a company later? No, it's not difficult. You can that's very, very common. You can transfer a trademark with IP Australia. Now, if you've registered like in 10 countries, uh, you have to do 10 transfers. So in that sense, it would be um, a headache. But just with IP Australia, if it's an Australian trademark to move from an individual to a company, you just fill out a trademark transfer form. You need to have like a transfer agreement, which a lawyer can quickly draft for you. IP Australia doesn't currently charge a fee for the transfer, so it's not a big deal to move the trademark in most cases. Yeah. Simon asked earlier, how do we protect the brand IP globally? I may have answered that, but I think I mentioned you can start with Australia, but you need to register in each country one at a time, or you can use this thing called the um, Madrid Protocol to register in multiple countries. Um, Kasia said, does IP Australia only do ANZ region? They just do Australia, not ANZ. So there's a New Zealand IPO as well. And yeah, there's a few other questions coming through, but unfortunately I have to jump off. So if people want to follow up with some questions over email, do feel free to do so, and I'll do my best to answer them. But otherwise, I hope people found this useful and enjoy doing these all the time. So we'll do this again next month, and I hope to see you all there. Thanks so much, everyone. I'll see you later.